Nearly 3 years after protests that rocked the nation's capital, we have a verdict tonight in the trial of a key organizer, Pat King. King was convicted of 5 counts, including charges of mischief and disobeying a court order. CBC's Sarah Galashan has more on this story for us tonight. So, Sarah, bring us up to speed.
Yeah, Travis, so this was a trial that was held back in the spring. It went over 3 weeks, and a lot of evidence was heard as to the role that Pat King played. Did he or didn't he play a role in the organization and the instruction to protesters who were involved in this so-called Freedom Convoy that happened? The verdict has come in, and he has been found guilty of 5 of the 9 charges that he was facing. He was, you'll remember, arrested back in February 2022. And notably about Pat King, he streamed the process of being brought into custody by police. He was somebody who was previously known to be prolific on social media and liked to post videos in which he was not shy to express far-right opinions. When it comes to the 9 counts that he was facing and the 5 counts of which he was found guilty, 2 of them were counts for disobeying a court order, 1 for mischief, 1 count for counseling others to commit mischief, and as well 1 counseling to obstruct a public officer, a police officer. And he, as I say, he was found guilty of those 5. He was found not guilty of 4 others, and 3 of them deal in intimidation, and then finally also not guilty in a case of obstruction of a police officer by himself, and that relates to him being taken into custody and that arrest that was made. Outside of court, Pat King, he came out with his lawyer. He stood there beside his lawyer. He didn't talk. His lawyer very concerned that if he were to speak to the media, that he would somehow violate bail conditions that are in place. But she was quick to point out the not guilty on these 4 counts, saying that she believes that this is significant, the fact that these were the particular 4 that he was found not guilty of. I want to play a little bit more of what his lawyer had to say.
Mr. King was acquitted of all charges related to inciting any form of violence, specifically intimidation of Ottawa residents, any other persons involved in the community, or anything of that nature. And the judge went out of his way on several occasions to indicate that, in fact, Mr. King and all of his prolific social media posts indicated that we are to remain peaceful. We are to stay here, and we're going to stay, but we're going to stay peaceful.
Okay, so Sarah, you know, this convoy protest made headlines around the world, and a lot of people will want to understand the reasoning for this verdict. What can you tell us about that?
Right, and to your point about the headlines that it made, remember this was a demonstration that went on for weeks. You'll remember because you were in Ottawa at the time. It started January 2022, finally ended about mid-February 2022. It was a protest against public health restrictions and vaccine mandates, and the effect essentially in downtown Ottawa, around Parliament actually, was gridlock, and there were residents in those neighborhoods that are nearby who were complaining about constant fumes coming from semi-trucks and as well constant honking from these vehicles. The big argument here was whether or not Pat King, as I say, was a leader in this. And that was really, during the 3-week trial, what was argued back and forth between the 2 sides, the crowd arguing that he was, the defense saying essentially that he just was somebody with a large social media following who liked to post and people liked to listen to what he had to say. What matters, though, is what the judge had to say. A lot of these social media videos were played as evidence in court. And in one of them, one example here is that he's heard to say, hold the line. Now, the judge in this said the term hold the line in the context of the Freedom Convoy could have amounted to just a greeting between 2 protesters. But when coming from Pat King in a social media post, followed by so many followers, that it really did amount to telling people, the judge said, to not moving despite what a police was ordering you to do. So in his decision, Justice Charles Hackland determined that Pat King was an influencer. Now, influencer being a term that, of course, we are well aware of, well acquainted with in terms of social media. It's referred to usually when somebody has a large following on social media and they are online and they are advising them, you know, what to do and why they like to do it. Anyway, News Network earlier today did talk to a lawyer about the legal context of that term and what it can mean in court. Take a listen to that.
You can be an influencer about fashion, or you can be an influencer about protest and about civil disobedience. And ultimately, Mr. King was held to be an influencer about those things. And he has been held accountable because we have party association laws in our books that allow judges to find that people are a party to an offense or responsible for an offense, but they don't have to actually be the person who committed the offense. And it's a clear illustration today of just that.
So Pat King is expected to be sentenced on January 16th. They have set aside a day and a half for that. His lawyer indicating that she is going to be seeking time served and probation. There are other verdicts that we are waiting for, I should mention. Tamara Leach and Chris Barber both have had trials that have wrapped, and verdicts are still to come. And both of them also similarly described and accused of being leaders in this. So we'll be watching closely for what those verdicts might be. And additionally, the federal government has appealed a decision that found the government guilty of violating the Charter of Rights and Freedoms, because, of course, you'll remember the government did invoke the Emergencies Act. So that appeal is expected to have some movement on that into the new year. Travis?
Okay, Sarah, appreciate it. The CBC Sarah Galashan in our Vancouver newsroom. Well, to help us unpack the verdict in the Pat King case, we're joined now by Michael Kempa. He's a criminology professor at the University of Ottawa and joins us tonight from that city. Michael was also one of the experts who advised on the commissioner's recommendations regarding the use of the Emergencies Act. Thanks for being here. Appreciate it, Michael.
Okay, thanks, Travis.
Are you surprised by today's verdict or not really?
Actually, not at all, in the sense that the court has brought down guilty verdicts on those things which are the lowest thresholds, things to do with mischief, which is all about preventing people from using property for its intended and essential purposes. That was pretty much obvious over the course of the Freedom Convoy. And then not bringing down guilty verdicts on matters that had to do with aspects of deliberate violence. It didn't seem that the Freedom Convoy was putting up a barrier or suggesting that only supporters of the Freedom Convoy would be welcome in public space.
Well, he was not found guilty, as you mentioned, of some of the more serious charges, including intimidation. I know that there were some residents in downtown Ottawa at that time that felt intimidated. What did you make of that?
Well, you may have felt intimidated. It's more to do with the intentions of the accused. So it is clear from the evidentiary record that there was an intention to gridlock Ottawa. There was an intention on the part of Mr. King and maybe others to prevent people from going about their daily business, to lock things down in a way, bear hug as they put it. But it's not clear that there was an intention that they would exclude anybody specific, any identifiable group from public space. That's where you need to go for the criminal charge of intimidation.
As we know, at the beginning of this convoy, there was honking all across downtown Ottawa. It was very difficult for residents to sleep and to get any kind of peace. King was found guilty of counseling others to disobey a court order for the no honk injunction that eventually came into place. What does this ruling suggest about the legal consequences of encouraging others to break court orders during protests?
Well, we have a long tradition in Canada around what counseling another offense means. You can be guilty of counseling any offense in the criminal code, and then your punishment is exactly the same as though you had committed the offense itself. Counseling is more than just glorifying something or generally encouraging people to do it. It's about providing a little bit of a pathway for people on the ground to engage in that behavior. So specific advice, providing money. And these are the things that Justice Hackland zeroed in on in convicting Mr. King on counseling.
As Sarah just mentioned there in her report, we are still waiting on the outcome of other trials related to the Freedom Convoy, including those of Tamara Leach and Chris Barber. What kind of impact do you think today's ruling could potentially have on each of those cases?
Well, it's clear that the mischief threshold is quite a lot lower than perhaps defense counsel for Leach and Barber might have liked. However, on counseling, Leach and Barber are a little different from Mr. King. Mr. King was very out front and center, all over social media, on the streets. Whereas Leach and Mr. Barber were very much on the back scenes in the hotel. In those circumstances, it will be harder for Crown prosecutors to prove that they actually provided that pathway, encouraging other peoples to offend on the ground.
Let me just finally ask you what kind of precedent you think that this sets for future protests and also protest organizers who want to do something similar or might want to do something similar down the road in this country.
Well, we're in a little bit of a race right now, in the sense that we have accelerating protests, some of which are becoming much more confrontational on the ground, while the courts are very gradually settling what exactly our laws are around what is legal versus illegal in protest. Politicians haven't done it. So far, it's much clearer that mischief is a lower threshold, intimidation is a higher threshold, and counseling is a higher threshold altogether. It's going to remain through appeals another couple of years. We're going to see if the courts get us clarity quickly enough for all the protests that are manifesting on the ground and gathering pace.
Okay, Michael, good to see you. Thanks for coming on tonight.
Okay, thank you.
Michael Kempa, Associate Professor of Criminology at the University of Ottawa, joining us from the nation's capital.